Let me first of all thank Professor Anna Leoczki, who has invited me to this important event. Thank you to the Faculty of Philosophy of ZIEC. And I would like to say hello to Gabriela Nemeth as representative of OFI, that is one of EULITA associate members. Your program is ambitious, and the topics chosen are perfectly in tune with the present situation all over Europe and beyond. The constant struggle between human beings and machines, this time translators and neural machine translation, the building and use of legal terminology and legal language, the comparison between national legal orders, and the difficulties legal interpreters and translators face when working at court. All these affected by the COVID-19 pandemic that obliges us to change, to modify our way of living, to adapt our work and the way we work. First of all, I will dwell on briefly on how judges organize their hearings at national and international level during the lockdown. In all countries, civil, administrative, and criminal procedures were suspended, with rare exceptions in case of urgent matters, in particular in the criminal context. We are all aware that new technologies are usually absent at court, in several of our courts, so that it was initially impossible to examine, to interrogate a foreign accused person who needed an interpreter, with the consequence that too often the fundamental principle of presumption of innocence was overturned and the suspect detained for sometimes quite a long time before being heard. This was, I think, maybe the worst effect of the pandemic in the context of judicial procedure. In a certain number of cases, judges or prosecutors appointed legal interpreters at distance. Interpreters who were then obliged to work over the phone with all the difficulties and obstacles that this causes to the quality of the interpreting, for example, the sound and the impossibility of looking or seeing people at court. And from the point of view of ethics, we are all aware that talking on the phone is really not the best way to keep secrets or make confidential declarations. At international level, in particular at the Court of Justice, after a certain number of weeks of total lockdown, some hearings were organized at distance. You maybe know that at the Court of Justice, interpreters are present on the basis of what is the language of procedure, how is the chamber composed, what judges are there, what languages do they speak or do they understand. So it depends on the case, which interpreters, how many of them, with what languages. During the lockdown, the court organized some hearings at distance where judges, interpreters, and one technician were present in Luxembourg, while lawyers were pleading from their own office, from their own ministries. It depended on the case. Technical shortcomings were detected at the beginning here and there, but in the end, the primary objective was reached, which is that of discussing a case that would have a European effect. I won't enter into details about technologies and new technologies, because this is not my cup of tea. Of course, I don't despise them. I do recognize their undoubtful value. And my presence today in remote shows the weight these instruments have. Instruments that are the products of human intelligence, human creativity, human ability. Indeed, new technologies offer enormous opportunities to our colleagues, to our professionals in general, and also to universities. Many of us gave courses online. Most of us had the chance to be offered online training. Participation at conferences, seminars at distance, as in our case today, is only possible thanks to all these instruments, developed honestly at a very high speed in the last years over the world. I don't want to start a discussion on meeting at distance versus meeting in presence, because it's obvious that meeting in presence means friendly encounters, personal face-to-face, the possibility of taking a cup of coffee with Mr. Smith and a lunch with Mrs. Jones, discussing outside the room about topics that maybe have nothing to do with the conference itself. All of these meeting in presence, it's a real pleasure. However, on the other hand, the use of new technologies during this critical period allows several people to choose among a very high number of subjects, those that are the most interesting for them, that meet their interests. And for our profession is in particular very important to use new technologies, because we can attend courses of legal terminology, deepen our languages knowledge, improve our technical skills. There are courses on consecutive, on ethics, and so on. So without being particularly fond of new technologies, I admit that we have to appreciate their importance and take advantage of them without, of course, being annulled or deleted by technologies. I really hope to meet you face-to-face one of these days in the near future. One of the subjects I'm really fond of is law, together with languages. Let me start citing a very recent judgment of the Court of Justice. The case is case C/564/19. So Court of Justice 564/19. It's important for me to talk about this case because it concerns Directive 2010/64 that we consider our directive, and secondly, because it is a case coming from Hungary. The judgment was pronounced by the court on the 23rd of November, so 10 days ago. All language versions can be found on the website of the court, curia.europa.eu, curia.europa.eu. The origin of this procedure is a preliminary ruling request coming from a Hungarian judge. You maybe know that according to Article 267 of the Treaty on the Functioning of the European Union, national judges may request the court to give a ruling concerning the validity and or the interpretation of acts of the institutions that they, the national judges, have to apply or consider they have to apply in a case pending before them. Now, acts of the Union, of the institutions are regulations and directives, the legislators being the European Parliament and the Council. in this case, the question, as I said, concerned interpretation of two articles of Directive 2010/64. In particular, Article 5, and allow me to quote it, member states shall take concrete measures to ensure that the interpretation and the translation provided meets the quality required by the directive. And Article 2.5 that says, and I quote, member states shall ensure that accused persons have the right to complain that the quality of interpretation is not sufficient. These are the two articles that the Hungarian judge took to the attention of the Court of Justice. And it was up to the Court of Justice to explain the meaning of these articles and interpret them. The legal reasoning of the court in this case, that concerns other questions too, are under points 102 to 138 of the judgment. And the court rules that member states have indeed to take concrete measures in order to ensure that the quality of the interpretation and translations provided is sufficient to enable the suspect or accused person to understand the accusation against him or her, and in order that that interpretation can be reviewed by the national court. Now, this means that member states have to adopt measures that concretely allow judges to act in case the interpretation performed during one of their hearings is not sufficient to safeguard the fairness of the proceeding. Now, this is the first time that the Court of Justice, which, let me remind you, is the highest court in the European Union, the first time that it takes such a clear position on Directive 2010/64, and in particular on quality. And the conclusion the court arrives at is of fundamental importance for us as legal interpreters and translators, since this decision has to be applied in all member states. Why? Because preliminary ruling judgments or judgments coming from a preliminary ruling requests have to be applied by all judges in all over Europe in case they are faced with a problem concerning that rule that was interpreted by the court. So if another judge in Croatia or in Spain or in Estonia will be confronted with a case concerning Article 5 and Article 2.5 of Directive 2010/64, these judges will have to take into account the interpretation given by the court and apply it to their case. So, for example, if the member state, a certain member state will have decided that in this case, the interpreter has to be replaced, the procedure has to be suspended, or anything else, this judge will have to do that. So it is really a very, very, very important judgment, and I think we have to insist on talking about it everywhere. Before coming to my conclusion, let me add some words to another judgment that I discovered, I was informed about only yesterday. This one coming from a Court of Appeal in Ireland. It is a Court of Appeal's decision of the 18th of November. November is very fruitful for this kind of judgments. The Court of Appeal applies indirectly, of course, Directive 2010/64, as well as the European Convention of Human Rights. in fact, due to the insufficient quality of the interpretation that the Court of Appeal declared, the Court of Appeal itself found that the witnesses' evidence had been materially misrepresented and distorted, that the fairness of the proceedings had not been safeguarded, and that therefore the appellant's trial was unfair. So the Court of Appeal, due to the insufficient quality of interpretation in that particular case, decided to stop the procedure without determining for the time being the substance of the case. So the case is waiting now. Of course, the interpreter will have to be replaced. We don't know yet whether he will be punished in one way or the other, but from the point of view of qualified and competent interpreters, this is a fundamental judgment. So I think that we cannot but oblige ourselves to insist with more energy, more passion on the necessity of raising awareness among judges, among prosecutors, lawyers, all judicial operators, in order to let them understand how important it is for justice to have qualified interpreters who allow the judge to develop the procedure, to go on and to come to the end of it with a final decision. In this case, the suspension of the procedure in front of the Irish Court of Appeal is really serious, because the facts of the case, the merits of the case, was very difficult to accept. So please do disseminate as much as possible these judgments. I will send you, if you prefer, the references to these two judgments, because this is important also and primarily in the interest of justice. And these judgments, I think, could maybe convince our students and all those who, despite not being qualified legal interpreters or translators, accept assignments at court. These judgments, I repeat, could convince them of the importance of training on legal topics, on ethics, of course, on languages, in particular on the mother tongue and on the foreign one too. So we have also to be conscious of the importance of the continuous training during the whole career if we want to keep a certain level of quality in our performances. It is, I guess, clear from what I've just said that the European law, since the beginning, has influenced the legal language as well as the national law. And if it is true that the legal terminology employed in the legislative acts of the EU has to be interpreted by the Court of Justice according to European criteria, and maybe a word, a notion used in a national law will be interpreted in a different way at an European level. I mean, the same word can be used in both or legal orders, but with a different meaning. As I said, even if they have to be, or they can be interpreted in a different way, and according to national and European criteria, it is also clear that the European law and terminology influences the way the national legislators adopt their legislative acts and the judges write their own judgments. I think that it is our task as legal interpreters and translators to study, as I already said, to keep an eye also on the developments in the legal environment we work for, to keep in mind the role we play in the courtrooms and in the police stations. We don't have to forget that the life of foreigners also depends on our skills, on the respect we have for them, on our responsibility. And only if we are aware at first of that, only in this case will judges, prosecutors, lawyers, police officers recognize our role and respect our job. This is my conclusion. I thank you very much for your attention. I'm here for, if necessary, questions. You can also write to me. And I wish you a very fruitful further discussion. Thank you.